have been very lucky to work with Damir this past year and to learn about his vital human rights work in the area of internet shutdowns, facial recognition technology, and encryption. Damir is currently representing online messaging service Telegram before the European Court of Human Rights in relation to a complaint pertaining to a ban imposed by a Russian court on Telegram after Telegram refused to hand over decryption keys needed to access users' confidential messages. This is the first case concerning end-to-end encryption to go before the European Court of Human Rights, who will be considering whether this ban constitutes an interference with freedom of expression and whether such an interference is necessary in a democratic society. So this case will have a profound effect on end-to-end encryption and the balance struck between privacy and national security in Europe and beyond. Agora is also before the European Court of Human Rights over the collection of protesters' biometric data via facial recognition technology cameras in Moscow. So they are arguing before the court that the collection of this biometric data has no legal basis, violates the right to privacy and the freedom of assembly as protected under the European Convention of Human Rights. So they are also arguing that using FRT at an opposition rally really amounts to a discrimination based on political views. Agora is also has also carried out litigation in respect of internet shutdowns and very recently drafted a submission to the UN concerning the shutdown of the internet in Belarus last August. So without further ado, as Damir will have many interesting things to tell us in detail, the floor is yours, Damir. Thank you.
Thank you very much, Olga. Nice to see you, colleagues, and thank you for your interest to what's going on in Russia. I will try to give you a short picture of Agora's work in this field, and I will try to probably to leave more space for questions. I believe that some of these issues are actual and important, not only for a country, but for your organizations and states as well. Just 2 words about Agora, which is a network of lawyers which was established as an NGO in Russia, which focused on police torture in 2003. And since that time, the network was growing. In 2013, the organization was banned under foreign agent law. And since that time, we have to operate as an informal network. But actually, the ban just gave us additional kick to move forward. So we've never had such so many cases, so many lawyers as now, and that as the situation in Russia, the political situation and the situation with the human rights is worsening within last years, there is still space for human rights lawyers to work in different fields. Me and my colleagues, we focus on freedom of the internet since 2018. Since 2008, and we monitor the situation, public annual reports on the situation with the freedom of the internet in Russia and politically motivated surveillance. In some quite big and important part, together collaborating with our partners from INCLO, and it's very fruitful for the Russian civil society and for the human rights in Russia. I believe for now the network of Agora includes more than 50 lawyers in different parts of Russia, and we work not only within the country but trying to communicate, collaborate with the partners and colleagues from different parts of the post-Soviet space, basically in Central Asia, but also in Belarus and some other post-Soviet states. Well, it's. I believe that it makes no sense to speak about litigation without giving a brief picture on the situation with the freedom of the internet in general. I believe that Russia is a quite good example of what can happen with the internet freedom. If the civic society will try to not to pay too much attention to what the state does. So we very fast moved from absolute freedom to total control, which we have now. In 2012, when the first bill even mentioning the internet was adopted in Russia, we very fast moved from content filtering to pressure on global platforms and the attempts to build a Russian sovereign network, trying to copy Chinese experiences and building a great Russian firewall. I believe that all the cases, the strategic cases on which we'll speak today, resulted as becoming a result of all these policies and the state policies. Russia is in quite unique position because contrary to our, for example, European partners, Russia has quite popular and well-developed national local services. We have our email services, searching engines, social networks, messengers, and so on and so forth. So first, the state, when the state decided to control the internet in 2012, they focused on controlling local platforms and let the global IT companies to operate almost freely. The things has changed within the last 20 years when Vladimir Putin became the president for the first time in the beginning of the millennium. He established control over federal television, and the biggest old federal TV channels were put under governmental control, but the internet remained absolutely free. So until the audience and the penetration was quite low. So in 2003, for example, the internet audience in Russia was about 3 million people. So it was few percent of the population. Now we have 95 million active internet users. So it's more than 80% of the population, and the things have changed in 2012 when the government started to make first attempts to control this huge, absolutely uncontrolled source of information. And during the last 10 years, we saw the changes in the public opinion and the attitude to the internet from some space where you can find some funny entertainment or scientific information for your studying, to the main source of social political information and a platform for mobilization of the civic activists. So I believe that was the main reason, and the Arabian Spring definitely was one of the first events which pushed the Russian government to establish control. So as I have said already, they started from content filtering, and the first legislation in this field was dedicated to building a blacklist of websites, which was spread among the telecom operators and they had to block access to any link which was included in the list. It was not too effective because people started very fast, and the popularity of VPN services and proxy and the public awareness about all these tools increased extremely dramatically. So within 1 or 2 years, every mobile phone, every laptop had almost everyone had a VPN, which make this blocking of websites on the telecom operators level absolutely senseless. After that, they started to frighten users, those people who share information and comment the political situation. And since 2015, we saw the huge growth of the number of internet users being prosecuted or even put in jail for years for just sharing some information online or liking and reposting something in social networks. But initially, the main target for the prosecutors and the police was the audience of Russian-based internet services, primarily a Russian copy of Facebook, Vkontakte, which is the most popular social network in the country. So now 75% of the population has accounts in VK, and the companies under absolute control of the government, because it's situated within the borders, and they had the servers in Russia, they had the personnel in Russia. It's easy, very easy to control, and the money are also inside our country. So the attitude to the global platforms, such as Google, Facebook, Twitter, YouTube, and the others, for much longer remained more light. The state tried to negotiate with the companies. We saw how the top management of these global platforms came to Russia. They have met with the telecom authorities, which basically are just a proxy for Federal Security Service. And no one told public about the results. So we saw just press releases from Russian telecom watchdog Roskomnadzor that everything is going fine. We fruitfully negotiate, and very soon Google, Facebook, and Twitter will fully comply with the Russian legislation, which was quite severe for that time. So for now, all the social networks which have more than 500,000 active users must open legal entity in Russia. They must store all personal data of Russian users within the Russian borders. The so-called Yarovaya law, under this bill, all online services are obliged to store all users' correspondence, including text messages, audio messages, video conversations, any materials which people send or share using this service. They must store all this data within 6 months, and all metadata must be stored within a year, and all this information must be provided to the Federal Security Service, and they don't need any court decision to request any sort of information. So that was the first effort to force the first attempt of the Russian authorities to force the global platforms to comply with all these requirements. In 2016, a list of so-called organizers of disseminating the information online was established, and in the beginning only Russian companies were included in the list, so all those services which are included must comply with all these requirements. But in 2017, a Telegram, which was built by a Russian citizen Pavel Durov, who was a developer of Vkontakte as well, but he positioned himself as an international company not related to Russia. Anyway, it was one of the first global platforms which was included in the list. And within a month, the Federal Security Service sent a request, the first request to share the information on the messaging communications of Telegram users. And they requested the decryption keys, because it's also one of the general provisions of this Yarovaya bill, that all the services which use encryption, any sort of encryption, should provide the keys, and should build a backdoor available for the Russian authorities in person for Federal Security Service. The Telegram refused to do that, and it was fined in the beginning. The fine was quite small for IT company. It was about 10,000 euro. But anyway, it was just the first steps, because after a couple of months, district court in Moscow ordered total blocking of the service, as it is the most severe penalty for the company to be banned in Russia. That means that all the telecom operators should block all IP addresses. All hosting services must refuse to host the services until the company will comply with the legislation. And Telegram subsequently refused to provide the keys to the Russian government. We started to represent the company at the stage of fining it and appealing against the fine in Moscow court. And since that time, the position of the authorities have changed a couple of times. First, they said that we need only the information of these six terrorists which were charged with terrorist attack in St. Petersburg in spring 2017 in St. Petersburg metro. But the request was was proved by a secret court order. So no one saw the substance of the court decisions. We were provided with only the numbers, and no one knew whether these court decisions exist in reality, or it was just it was just a tool to prove the request. While the trial, the position of Federal Security Service and Roskomnadzor have changed, and they, at the end they said that they don't need only this, the information on these 6 accounts, but they want a backdoor which will allow them to decrypt all communications of the users. It was an answer to the company's position that end-to-end encryption, which is used in secret chats of Telegram, do not allow the company to interfere with the communications, to intercept them, and to provide the government with any information, and at the end with the correspondence with the content of the messengers. Well, the position was that we or the government was that we suing you for half a year. That was enough time for you to build a backdoor. So very easy. And after the Telegram once again refused to do so, the court ordered a blocking of the service, and they started to block all IP addresses which were used by Telegram. It was so-called IP genocide in Russia, which took place in May 2018, when the telecom authorities tried to ban and to include into that blacklist of links and websites all technical IP addresses which were used by Telegram, including these cloud services of Google, Amazon, and all the biggest hosting services in the world. So at the peak, they blocked 20 million IP addresses at one moment, and Telegram still worked. So there were no any specific troubles for Telegram users in Russia for that time, but all the other part of the Russian part of the internet suffered a lot. So we launched a hotline for people, for common people, for users and for business owners who suffered from these blockings, because a huge number of services stopped working, including online stores, some government websites, advertising platforms, video streaming Russian services, and so on. So we received thousands of applications, and we suggested people to go to court, but unfortunately only one very brave woman decided to do so. So there is the only one case of the applicants who suffered from this IP genocide, which passed through 4 instances in Russia, and now this case is pending in the European Court of Human Rights. So we'll see what will go on further. But anyway, in last summer in June, the government very unexpectedly announced that they now have no any tensions with Telegram. They appreciate the company's efforts in counter-terrorism and banning the terrorist accounts. But actually, that was the initial position of the company, that we ban the terrorist content by ourselves. We don't need you to control it. So at that time, Telegram launched a special Telegram channel where they day by day reported how many terrorist accounts or channels were banned and for what reasons. So from that side, there were no charges against the company. But anyway, Telegram did not provide the government with any decryption keys. They did not comply with any requirements of the CCRI bill, but the service was unbanned. Since 2018, the Russian audience of the service, Telegram Messenger service, increased from 6 million up to 30 million people. And even some state agencies continued sharing information and publishing press releases via Telegram, while the service was officially blocked and banned in Russia. So it was quite strange position, but anyway, for us, the key issue in all this case was the balance between the privacy and security, and this request to provide a backdoor to all the communications allowed us to raise this issue before the Russian courts, which said that they actually refused to strike this balance, and they limited themselves with the position that as the state agencies which requested the decryption keys acted in accordance with the legislation and within the legal rights, there were no violation of the users' rights, and the privacy of the users were not affected. It's quite strange for me, but it was said in official court orders, and it was announced as an official position of Federal Security Service. Anyway, we included all these things into the application to the European Court of Human Rights, and the case was communicated to the Russian government this fall. So now we are in process and waiting for the position of the government. It will be very interesting to read. But this core case was not the only one on this issue. We also, we as Agora and in collaboration with our partner organizations in Russia, worked on a number of other cases, including the so-called Fight for Telegram campaign, which allowed our colleagues from Roskomsvoboda, group of civic activists fighting for freedom of the internet in Russia. They collected 35 applications from common users of the Telegram who decided to appeal to the court on this. First, the requirement to share the decryption keys, and second, to blocking of the messaging service. It was quite hard work because the website which was launched, and it provided a special online form which you could fill in, stating that you are ready to participate in the legal proceedings. So you had to fill some mandatory fields pointing your name, your city, your relation to the service. So when you registered your account, how you used and what for you used the Telegram, and so on. At the end, this online form produced an application to the court. So you had to pass through 4 instances under supervision of the lawyers, to pass through 4 instances on the national level, and then send authority form for the lawyer who will submit an application to the European Court of Human Rights. So in the beginning, there were 7,000 people who registered in the system. At the end, we collected about 100 applications to the domestic courts. And after that, only 35 people finished their activity at the European Court of Human Rights. The applications are united and registered, so we're now waiting for the communication. Next, there was a complaint submitted from that brave woman who owned an online store of design posters. Her business was totally destroyed by that IP genocide because the blocking of these hosting platforms made her website unavailable for users for a year and a half. So she even changing the IP addresses didn't help her, and the problems with access finally made her to decide to quit, to stop the business. In the beginning, it was quite successful company which produced a few thousand US dollars per month. So this quite successful business was totally destroyed. The application is also in the European Court of Human Rights. Now it is communicated even earlier, even before the core Telegram case. So we received the position of the Russian government, which says that this case is not connected to the Telegram. And if the applicant thinks that her rights were violated, she should sue the telecom operator who banned the IP address, but not the government. It's a general position of the Russian authorities on all these blocking cases. We receive it since 2014 when we submitted the first application of the website blockings and these collateral blockings as well. The Constitutional Court also considered such sort of case and said that the only mechanism which is considered to be effective for the website owner who suffered from this collateral blocking is to sue the telecom operator, which has right to choose what mechanism of blocking to use. In fact, the Russian legislation allows the telecom operator to choose between banning the IP address, the URL, or the domain name. And at the beginning, only the biggest telecom operators could afford to ban specifically the web pages by URLs. The absolute majority of them had to ban IP addresses because the technology was much cheaper and easier because they had not opportunity to use all this expensive equipment. Because at the end, in Russia, we have more than 4,000 telecom operators, and only 6 of them control 70% of traffic. So the absolute majority of the companies are small telecom providers, which has few hundreds or at least thousands clients. They definitely cannot afford themselves to use such expensive and serious systems. Anyway, the right to choose the mechanism belongs to the telecom operator. The government decided that this is the only one person which is obliged to and which is responsible for defending human rights online. Anyway, this summer we received the first judgment by from the European Court of Human Rights on the collateral blocking of website case. Vladimir Kharitonov against Russia, which which gives the further development of the position of the European Court on this issue, which was initially declared in the case Ahmet Yildirim versus Turkey in 2012. So that was exactly the case that allowed the Constitutional Court to say that go and sue your telecom operator. Don't bother the state agencies. But contrary to that, the European Court said that it is the government which must choose the most thin instrument, and to keep in mind all the possible collateral damage on these measures which are taken to restrict access to any illegal content online. So we believe that this will allow us to continue this and to develop this position on the Telegram case, because the collateral damage was much bigger. The collateral damage for the website owners and the IT companies in Russia were much bigger than the damage to the Telegram Messenger company, which actually felt absolutely no problems with operating in Russia. So the case for now is on this stage. Two cases are communicated: the core case of a Telegram and the application of the IT company. The group of applications from the users, among which are two journalists, which who appealed that the ban of the service and the threat of compromising the encryption threatened not only their personal communications, but their professional journalistic work, because it is, in some situations, it is necessary for them to communicate with their sources of information via confidential channels. And so the ban of end-to-end encryption in Russia threatened their professional activities. So now we are waiting for the ball is on the side of the European Court, as we received the government position. I should make a short remark. We so often say European Court that you probably can think that it is the only effective instance in Russia. And all our work is done keeping in mind that you will at the end have to go to the European Court. Basically, when we started our work 15 years ago, we focused on the domestic level, and we always tried to be successful on national level. We didn't want to, we actually never worked with the European Court until probably 2011, 2010, as no one in Russia believed that this can make any sense. But actually we had effective remedies, at least as the Supreme Courts and the constitutional courts, which especially in non-political issues were quite effective. They in some regards were even more progressive than the European Court, which we must confess now is more conservative than we wanted, unfortunately, and it is not too fast. I believe that if the first case on the collateral blocking of websites was considered in 2014 when we submitted it, but not in 2020, probably the IP genocide in 2018 probably wouldn't take place at all. Anyway, but for now, the space for human rights lawyers is shrinking, and it's almost impossible to argue with the state in national courts, especially on issues connected to freedom of expression, to freedom of the internet, and to right to privacy. And because all these issues are considered as very sensitive for the Russian authorities, and they're trying to not to put any opportunity to establish standards which will guarantee the human rights in this field. So more and more often, we now have to use the domestic courts just as a mandatory steps you have to do before appealing to the European Court. The same situation is with using the surveillance technology, which we faced in recent years. Russia started to build a huge, and now I'm passing to the next case, which is connected to use of facial recognition systems in Russia, which we started to build 2015 when Russia was nominated as a host country for the FIFA World Cup 2018. And it was the main pretext for Russian authorities to start building biggest CCTV system, which now includes 200,000 cameras only in Moscow, and all the biggest Russian cities have such systems, which are named safe cities. Within this federal program, huge amount of money is sent to the Russian regions to build these systems. Due to the legislation, any space where more than 50 people can gather together must be equipped with a CCTV camera. Any space where more than 500 people can gather must be equipped with a CCTV camera connected to the facial recognition systems. And Moscow, seems that Moscow now is building the biggest facial recognition systems in the world. And the opportunities we saw not while the World Cup in 2011, but the last year while the pandemic and quarantine, when the Moscow authorities used this system to control the quarantine violators. So the web cameras are installed in few locations. The first is on the entrance door of each building in the city, and they work as they can recognize the face and whether this face owner lives in this building or not. So is it guest or host? The next level is the cameras on the buildings, which in case of municipal buildings, schools, or some sorts of local authorities objects, they must have 4 cameras on each angle of the building. And I know the third and the highest level is the cameras on public spaces. They are most they have the highest resolution comparing to these small cameras on the entrances. And government says that they can recognize at one time hundreds of faces. They started to use the systems even before the World Cup on protest meetings and rallies in Moscow. So Moscow was the pioneer in this field. In recent years, when these protest rallies were so-called legalized, sanctioned by the authorities, they equipped the places where the rallies took place with the entrances with the metal detectors. So to participate in the rally you had to pass through this metal detector. There were 20 or 30 metal detectors in which entrance to the place. For example, from all the sides, other sides, it was locked with temporary fences, the police fences. So the activists started to see that all these metal detectors are also equipped with a sort of camera on the eyes level. So you couldn't pass through the metal detector without being captured by the camera. And always some officer sat with the laptop connected to this equipment and did something. No one knew what was that. Still, in September 2019, one of the activists saw a photograph, her photograph from different positions. So it was in her case file on the administrative case on the violation of the rules of the rallies rules. She was fined with $10 or something like that. But the main result was that we got the first evidence of using these facial recognition systems against protesters. And it was obvious that the camera focused on her face separately within a few minutes. And there were a couple of shots made from that camera in the case file. And that allowed us to launch a legal procedure, because before that, the authorities rejected the use of these systems against activists. And so we had no legal grounds for pursuing them. The position of the government was these data are used to provide the safety and security of the participants, as well as to detect wanted persons, wanted individuals on criminal charges not connected to this protest. So they seems, as to me, it seems that they launched some small PR projects, because after that they started to publish once or twice a month that they had detained a criminal in Moscow metro, and it was detected by these cameras. But more and more often we realized that some civic activists, which are well known to the police and to the so-called Centers E, which are police departments who counter extremism. In metro, for example, and we were questioned just with no charges, just questioning, detaining for a short period. They took them from the metro train to the police station, questioned, what are you doing? Who are you? Sometimes even the police officers were wondering why the system gave us an alert, and sometimes even shown the laptops with the photograph taken from social networks accounts, for example, open social networks accounts, or from the police database, which keeps all the photos of all the Russian citizens. So when you apply for a passport, you have to give your photo. Anyway, last week, one of our clients who were detained on the protests in Moscow, which took place on the 8th of January, said that the policeman showed him a screen of his laptop, where there was a short file on him with a photograph and some short information. But he was mentioned there, not under his real name, but with his small name, which he used only in his VK account. So we suspect that this facial recognition systems is connected and collect data from open accounts in social networks, and they take photos from them, and they take other data and the communications between and relations between different people. After this catching the quarantine violators last summer, and next big campaign and using these technologies were the recent protests in Moscow in January. So dozens of people were detained and arrested on the days of protests under the pretext that some police system alerted the officers and they were just questioned. But after the protests ended, the participants are still being questioned and arrested days after, weeks after. And they are identified by use of CCTV cameras, of the city cameras and specific police cameras, which were installed on specific special police vehicles, which were parked in the places of protests on the Moscow streets. And they had 36 round recordings of all the space. And including to this, now we see the mass evidence of using these technologies in the case files of the protesters in courts. And these evidence are proved with data from telecom operators and billing data of the mobile phones. So for now, they just take the billing data from the telecom operator that your mobile phone was in this place at this time, and the photo connected to your VK account, which also proves your presence. And this is enough for the court to fine you for participating in illegal protest. But this is now. A year ago, there were no such evidence. And that case of Alena Popova, who participated in this sanctioned legal protest in the Moscow city center a year ago, was the only evidence of use of such technology against the opposition and civic activists. We did not consider this, in this case, domestic courts as an effective remedy, because they normally says that as the police acted in accordance with their formal rights, there are no violation. In previous case on the intercepting of the mobile conversations in the case of Roman Zakharov, which was published in 2015, the European court said that in this situation, the national courts are not effective remedy. But we decided to try the Russian courts. No surprise. They said exactly what they said in the case of Telegram. Your rights are not violated because the police officer and the IT department of the Moscow government acted in accordance with the legal provisions which allow them to use such technologies. The only reason, substantive reason provided to us was that there are two different state agencies. One is the IT department, which supports and develops the system technically, they do not have access to personal data. So these photos are not related to any person, to any accounts, to any names, and so on. And the police do not have access to these CCTV cameras. That's strange, because the legislation says that police officers are allowed to get access to this system. Probably they meant that they have no access online in real time, but anyway, they can use these materials later and to check all these recordings when they need. So according to Russian court's position, this dividing the information between two different state agencies is normal guarantee for the security of the personal data. The next provision was that the mobile phone numbers, geolocating, geodata, and photos without connection to the real persons are not personal data at all, and they are not covered by the legislation on personal data and the guarantees which it provides for the citizen. And that was the general position of the Moscow authorities when they started to find people by using these cameras in entrances to the homes to find people who violate the quarantine rules. It is not a personal data. We just the IT department of the Moscow government does not have any access to personal data. They just identify that someone has left his home and give this information to the police, and the police then checks whether this individual must secure quarantine or not. And if he violated, then he is fine. So due to them, there is absolutely no problems. Our position before the European Court is can be summarized as follows. So the lack of legal basis for the interference while this domestic proceedings, we realized that the Russian legislation do not regulate the use of facial recognition technology at all. So it is not even mentioned there. And this position was formally proved by the authorities. They said that we now are only preparing the corpus of legal acts to regulate all this situation. So they use it for years already, but they do not still have any, not even a law, but even agency's decree, which will establish any guarantees from mail use. Next is lack of proportionality, because this using of this facial recognition on the peaceful assembly of people only under pretext to secure public safety and to identify criminals was too severe and did not allow people who wanted to participate in to enjoy their right to peaceful assembly they could not avoid the systems. Anyway, it's allowed the government to collect a database of the participants of opposition activities. And by the way, that rally was the major political opposition event of the year It's gathered dozens of thousands of people in the city center of Moscow, and all of them were included in a database which is not regulated at all. Thus, the technology was not politically neutral and was definitely used against political opponents. That's it. The application is submitted to the European Court. Now we are collecting the information on the use of this surveillance technology as well as facial recognition against participants of recent protests in Moscow. Our colleagues who worked on the ground reported that at least in 50 police stations, the detainers were forced to give their fingerprints. In 20 police stations, they had to provide the police with DNA samples. And in some of them, they were photographed in few fractions. And also the mass use of facial recognition technology to identify the protesters now is proved by thousands of case files. So I believe this will allow us to make some further steps on the national level. Now we are only in the beginning. And the last but not least case is dedicated to the government internet shutdowns, which is also a quite interesting thing in Russia. Because it is the only one case which has the official proof of internet disruption. Seems that Russian authorities use and turn off the at least mobile internet in places of mass protests were identified by activists, but the only evidence were the data from the applications which registered the change of from LTE to edge communication. So the activists and volunteers who decided to help to collect the evidence just in the places of the disruptions, they sent the screenshots and saw that telecom operators do not provide LTE or 4G access at this time. Normally, the authorities refused any any charges in these government internet shutdowns. The telecom operators said that the disruptions were caused by too many people at one place trying to stream, to communicate, to call, so it was a technical problems. The only one case took place in North Caucasus in Ingushetia at the end of 2018 and in the beginning of 2019. Ingushetia is a small republic in the North Caucasus, which has a border with Chechnya, probably one of the most authoritarian place in Russia. And Chechnya is much bigger, it is much more powerful, and they have certain territory contradictions with Ingushetia. At the end of 2018, the head of Chechnya, Ramzan Kadyrov, and head of Ingushetia, Yunusbek Yevkurov, at that time, they negotiated and decided that some part of Ingushetian territory must be transferred to Chechnya. It was absolutely a public decision, absolutely unexpected unexpected for the citizens. No one even knew until the official announcement of the signing this agreement between two republics was done a few days before it was signed. So dozens, thousands of people spontaneously went to the city streets and started to protest. And the protest lasted for half a year. So they gathered from time to time in different places in the Republic. But the major rally took place in the administrative center in Magas, where up to 50,000 people gathered together at one time. And every time they found that the mobile internet was turned off. In the beginning, the telecom operators told that they suffered from certain technical problems. There are too many people in this space. Our equipment is was not ready. Sorry, we give you extra minutes or extra megabytes and apologize for the inconvenience. And that was, oh. But Roskomnadzor and suddenly responded to one application of one of the activists and said that the internet was cut off due to the order of state authority in the sphere of security and public order. So due to the legislation, only police and federal security service can do this, can issue such sorts of orders. And the legislation says that the orders must be addressed. So you can request cutting the internet or any other sort of communication. It can be a fixed mobile broadband, any sort of communication to any individual or a company or a group of individuals. So the legislation do not allow you to disrupt the entire region or entire city. And in these cases, the internet was cut off on the entire territory of Ingushetia. So that allowed us to sue Federal Security Service and the Ministry of Interior, the police. And they brought, the Federal Security Service was actually the governmental body who ordered shutdown. And they brought to the court 7 short resolutions, which consisted of 2 sentences. According to the legislation of the communications, we order to cut off 4G and 3G mobile internet from this time until that time, for a day or 2 in some cases, and for 2 weeks as the largest, as the biggest disruption in October 2018. And I said, well, the reason was that we had an information that some terrorist attack is being prepared in Republic. That's all. We asked the court, do you have any evidence of the terrorist attack? No, it's a secret information, we cannot provide it to you. And the court said, well, this is definitely secret information and it is not related to the substance of the case. The Federal Security Service, due to the legislation, is allowed to request an internet disruption. Thus, the rights of the protesters were not violated. And that's it. And that was the only one case in Russia when the government confirmed that it was its decision to cut off the internet. In all other cases, when the activists provided the evidence of switching mobile internet from 4G to 2G, for example, they did not prove it. And the Moscow courts, for example, refused even to accept the lawsuits and to open the proceedings against the telecom operators and the telecom authorities on that issue, referring to that this is regulated, this situation is regulated by the customers rights legislation. So you need to communicate with your telecom operator first. And the telecom operator says, well, you could not enter the internet within 2 hours. We offer you 1 gigabyte traffic and be happy with that. And that was it. But as to the internet shutdowns, while applying to the European Court of Human Rights, we had quite a wide range of international practice, referring to the general comments of the Human Rights Council of the United Nations, which referred to the internet shutdowns to ECOWAS Community Court of Justice, and as well as to the judgment of the Supreme Court of India from 2019, which you definitely know. And seems that the case which we brought to the European Court will allow it to, for the first time, to establish standards for the Council of Europe on this issue. We passed through all the HUDOC database of the court. It never even mentioned the possibility of internet shutdowns. Probably, I believe that in the Council of Europe, the governments never used internet shutdowns. And the Russian example is the first one. Unfortunately, the Belarus is not in the Council of Europe, and they cannot support this case by their own complaint, as during last summer, the few instances of the internet disruptions practiced in Minsk, in the capital of Belarus, were approved by the government, and we, together with more than 70 human rights organizations from all the world, including INCLO, referred to the special rapporteurs, or the UN special rapporteurs on freedom of expression, freedom of peaceful assemblies, and on Belarus. And we're still waiting for the ending of communication between the Belarus government and the rapporteurs, because it's unfortunately the procedure is not so transparent as the proceedings in the European Court, and the only document which we can receive as the process goes via diplomatic channels, the only document which we can receive is the conclusion presented by the government, which is published sometimes even months after it is submitted. So we still do not know the position and the consequences of this situation. But anyway, now we realize that the shutdowns for the post-Soviet space is becoming one of the most used tools to restrict for protests and to limit the freedom of expression for people who protest against dictatorship. And I'm glad. To be glad is not a good word for the situation, but I'm glad that we are the pioneers in this field, and it's very interesting for us to participate. And Indian experience is also very important, and the experience of countering this internet shutdowns is very important, and I believe will be very fruitful for Russian civic activists and internet activists, as we expect that the next year in Russia, as we have a parliamentary election this fall and presidential election within 2 years, 3 years, this period will be quite interesting and severe for us, and we'll definitely have an opportunity to experience internet shutdowns, use of facial recognition technology, and attempts to undermine encryption and security of communications. I very much thank you for your attention, and I would be glad to answer your questions if you have any.
Thanks a million, Damir. It's always a pleasure to listen to you and to hear all the detailed updates and all the work that you're doing in Agora. And you guys are certainly our pioneers in these areas in the Council of Europe. I was struck by something that you said there about the European Convention of Human Rights possibly being a bit more conservative now than maybe a few years ago. But there's some questions that may kind of tie in with that that we've had. So Sidesh has asked a question: do you think that your effort to bring this issue in view of international authorities will have any effect? And I might just ask the second question as well, because it's quite similar, from Archana. In your view, has international exposure of such issues in the past helped better the situation or worsen it? So I guess really the questions, I suppose, is how do you think bringing international exposure to these issues, how has it resulted for you guys, or how has it resulted for human rights maybe?
Yes, this definitely allow the experience and the decisions of other governments allows the new authoritarian regimes to refer to the progressive international practice. Actually, no one restrictive bill which was adopted in Russia within recent years was complemented with the references to international practices. Generally Chinese, but more and more often European one. For example, while adopting the legislation on the social networks, which imposes huge fines for refusal to remove any political or any other illegal content. It was based on German NetzDG bill, which was adopted a couple of years ago. So yes, definitely the repressions are also become more and more global, and the dictators also share their experiences and share best practices like we try to do. And the first question was about the effect which all this force can have. Well, I believe that speaking about Russia, we definitely had an opportunity to reduce the level of repression using international mechanisms. And that was not our fault that the European Court is too slow. It's a very good example, which I always refer to, is the criminal prosecution for extremism. Extremism in Russia is very widely defined, and it includes not only criticizing the government, not only the hate speech, but even supporting such activities. in sharing. So if you donate to NGO which criticized the government and it was identified as an extremist organization due to that activities, you can also be identified as an extremist. This legislation was very effectively implemented in Russia against political activists since 2008, when the first sentence for posting online was imposed on human rights activists and musicians in one of the rural Russian regions. And the first application to the European Court was submitted at that time. The judgment from the European Court came only last year. So it took 11 years for the court to consider the case. I believe that if the judgment would be delivered earlier, in 2012 at least, we won't have a Pussy Riot case. We won't have hundreds of such cases, because the Russian authorities, they still have to comply with such with positions of the European Court. But the speed of the delivering these positions, and well, extremism, frankly speaking, extremism is not too actual for the Russian society right now. Now we have terrorism, which is much more severe, and the number of terrorist cases for now is much bigger than the number of extremist cases. And the terrorist cases also include this politically motivated prosecution of human rights and civic activists as well. So we need this, well, we need this judgment from the European Court, but it's too late. So now the problems are much more severe, and we have to wait further developments. So that is not, the situation must not force you to quit or to stop, but I believe that the international institutions could do more, much more to protect human rights and to support human rights defenders in many states.
Thanks, Damir. There's another question here. Could you, so we've two questions, and we are very close to the end, but there's a question here about India's experience with internet shutdown and the importance of that to your case. So that's the Supreme Court case, I think, that you were referring to in 2019. But also there's another question about facial recognition technology. It would be great to just get those in before we have to go. But so first of all, could you maybe reiterate that this is from Yash? Could you reiterate the importance of India's experience with internet shutdown in your case or in your work?
Well, the importance is, to my mind, is quite big, because first, the situation is very much similar. So it's internet disruption in the area where the human activity, protest activity is taking place. And the second is that the European Court is very, if it has a possibility, it's very appreciates referring to the international practice. So we definitely know that the judges of the European Court and the registry and the secretariat of the court, they keep an eye on what's going on in all parts of the world. They follow the judgments of American Court of Human Rights. They follow the judgments of the German Constitutional Court, as well as the Supreme Courts of many Asian and African states, which in some regards are more, they moved much further on this route than the European Court, which, in some regards is too slow. So yes, we definitely expect that the position of the Supreme Court of India will affect the position of the European Court as well.
Thanks, Damir. So we just have, so just one more question then. I suppose I'll put the two together. So Siddharth Seem from HRLN. Hi, Siddharth. We just know Siddharth. But he has asked, are there any cases of challenged facial recognition technology being used at airports? Airports in India have been introducing FRT, which was initially run on a voluntary basis, but it is likely that it is being operated on a mass scale without specific information to passengers and without obtaining their consent. So that's a question about any challenges to FRT being used at airports. And there's a second question kind of in addition to that from Rashita asking, in the UK, there has been a challenge to the use of FRT in a football field without the consent of the audience, and it was declared unconstitutional by the courts in the UK. Could the same principle apply in the case of airports in India? So I guess the question is about, yeah, the use of FRT in airports. Has there been any challenges to that? And also, could a possible finding of this being unconstitutional in the setting of a football game or football field, could that help, I guess, any action in India?
As to the football, we do not still have evidence of use of these technologies against football hooligans, but in Russia, the Ministry of Interior keeps a list of individuals who are banned from visiting sport events, not only football, but any public open sport events.
And that
I believe that as well as the airports. Mm-hmm. I believe that the principles are common, the proportionality and lack of legal framework. But as to the airports, Russian state do not need to use these technologies at the airport because it has more effective tool as so-called сторожевой контроль. It's a search database which is conducted by the Ministry of Interior, and they include it's a list of people. Initially, they started to fill it with extremists and football hooligans. But now we definitely know that civic activists and human rights defenders are a part of the database. So it has specific branches such as hooligans, human rights activists, anarchists, extremists, etc., etc. And what this base is used for is to control the travel of the people who are included. That means that in Russia, you have to provide your ID card when buying a ticket to any sort of intercity transport. And it's, no matter a bus, a train, or an airplane. So as you provide your ID card and at the ticket desk, and the ticket officer sells you a ticket, your personal information is included in the database. And those police officer who included you in this search database, he immediately receives an alert that you bought a ticket on this specific flight or train. So they don't need to search you with the facial recognition camera. They just can come to your home before you leave to the airport, or they can stop you at the check-in desk at the airport. They did it this January when the activists from different Russian cities wanted to go to Moscow to participate in protests. At least 15 of them were stopped at the check-in desks. And that was the search database, not the facial recognition system. But okay. Anyway, they're developing the system in the airports under pretext of their security. So I believe that they will use it sooner or later. No doubt.
Okay. Thanks a million, Damir. I know we've really gone up against the time. I've really enjoyed listening to you and hearing what you have to say. I'm very, very grateful. I don't know if anyone from the Centre for Constitutional Rights would like to say anything, maybe? Is Sinead there?
I am here. Thank you so much, Damir and Olga. It was a very, very informative session. And I think each of us who are here would agree that I think we are facing similar circumstances and we are all looking at litigation and interventions at various levels. And I think whatever we have learned and understood from your experience, I think it will probably help us working ahead in whatever way, we find out to intervene in our country in whatever way possible. Thank you so much. It has been really, really amazing. Thank you so much, both of you.
Thank you to Damir. Thank you to everyone else.
Thank you very much. I wish you very good luck, and I hope we'll be in touch.
Thank you. Thank you, everybody.
Take care.
Thank you,
Bye-bye.
everybody, for joining us. Thank you so much.